months to address when my foot was severely broken. And so I had to file a lawsuit on WellPath and got them served the other day. And as soon as I got them served, they started to actually do something about it, but it's kind of like needs to be rebroke now. And it probably would have never happened if the bond issue was taken care of to begin with. And so I really regret not representing myself in this color. There's been a really, really terrible delay between the extradition and what's happened here that has spanned 200 plus days now.
Well, we only have a few minutes. I want to tell you that I thought about what you were asking for, namely about reducing the amount of prison I would be asking for. And so I decided, here's my thinking about this, is what if we do Concord if you get in, and if you don't get in, the sentences go to the court. So you could argue for anything. You could argue for probation. If you don't get into Concord, you could argue for probation, and you could argue for whatever amount of prison you take. Or no prison, obviously.
I have worked extremely hard on some things that need to be addressed today. I would be willing to possibly negotiate with the 1023 case for 2022. However, the 7348 case, there's no merit on those grounds of that charge whatsoever, and I can prove it today and have it dismissed because of what I know. I've gone over every page of the 1400 page discovery, every
So
aspect.
you would take that plea if I dismiss the 20, I'm not saying I'm gonna do it, I'm just spitballing here. If I dismiss the 2021 case, you would take, you would plead to it, I could witness tamperings that for stipulate going to Concord.
On the 7348, if you dismissed it, which I can dismiss it based on lack of merit, 100%. So with that being said, I'll prove that shortly, but with that being said, the 1023 case, which is 2022, would be in between stalking and harassment. And at that point, I would be willing to possibly take an F6 concurrent. I know it's a lot different than what you're thinking, but in a minute here, you will see, if not today, then the next time I see that 7348 is grounds for dismissal, 100% absolutely. And so that's all we're at anyways.
All right, so it doesn't sound like we're close. I just want to see if we're close.
I really do appreciate you like all the way though, and I want to be heard on it because you'll see, I understand that you've been stuck in the middle of this, okay? So, you know, we're both on different sides of the ballpark, and so I like talking with you. You're awesome. I mean, really, I've had no issues with you. But with that being said, these folks are angry about certain things that they can be upset about, but they're not grounds for what they're attempting to get me on. And at the end of the day, I deserve to be heard fairly and at least somewhat fairly, you know, negotiated. And there's some definitely, if you'll see in a minute here, they really pitted you in a bad spot because the police officer Medina really falsified statements and omissions. I know the record disregard the truth, even with that charge out there in the 7340 case.
All right, let me look for Officer Hack. So Officer Medina wasn't able to come today because he's on medical. So I had to file a motion for continuance. I don't know if you got that or not.
Yeah, and I've got a motion against the continuance as well because the time period has passed based on some statutes and case law as well.
So let me get Officer Hack so that if it does get continued, we can make sure that we're setting it on the date where he can be here for sure.
No doubt, and I still will, you know, discuss further with you into this. I just gotta be heard on a couple facts, so you can see that what I have to say has a ton of merit, and it will change your idea of it. I promise you. Thank you so much.
Thank you. That will probably be my first.
Second work here.
Yes, I think he's gonna be in Division 1.
Oh, what is that?
We lost Rebecca again. It's right next door. Yeah, Division 10 docket in general is being held
So it's
in
560?
Division 20.
160?
I don't, are you talking about the case,
It's
the?
literally the room next door.
It's the next one, I don't know.
Realize.
None of us have the room number.
Thank you, thank you.
Sorry, thank you for coming. Yes, please, yeah.
All right, good afternoon, everyone. We're on the record and I am going to take three matters. One is Mr. Judkins, one is Mr. Anderson, and one is Mr. Harris. And Mr. Harris should be appearing, I believe, from Teller County. And then if anyone else is on WebEx and hasn't gotten the memo, I'm in the middle of a jury trial and I had to go through today. So I'm just doing a couple of matters today. The rest of my matters are all going to Division 20. I'm gonna go ahead and, if you are not on this case for Mr. Anderson, Mr. Harris, or Mr. Judkins, you can go ahead and hang up and then go on to WebEx for Division 20. Judge Brady is handling the rest of my docket today, so I can continue with my trial in a few minutes. The number is the same number you called, and then the access code is 921-320-374 for Division 20, okay? And let's see, Ms. Avellaneda, are you here on a criminal matter? Well, everybody disappeared, the whole thing. So, anybody have a preference on who we start with? I'd like to start because the deputies are so limited. Okay, Mr. Judkins, we're gonna go ahead and start with your case, okay? And you can stay right where you are. I brought you in a little bit early just because of my calendaring issues today, okay?
I have a lot to say today as well.
Yes, it's gonna be pretty brief today, but you'll have a chance to have another hearing at another time. So are you representing yourself today?
Yes.
Okay, and we're here on 22 CR 1023, 21 CR 7348. I have Ms. Friedberg and then Mr. Judkins. And then do I have Mr. Melichar?
He came to see me and told me that he didn't want that.
Do you know what? He's probably not on notice. At 2:30. Okay, so we'll have to take a break a little bit later, Mr. Judkins, and call you a case because Mr. Melichar, that was one thing that we slipped through the cracks. That's my fault. He needs to be here.
I want to move to relieve him from his duty because of conflicts of interest that he's an ex-public defender, and after calling a ton of attorneys in town, just like you recognized last time with the Rodimer and Cush being in the opposing parties, there's nothing but conflicts of interest in the county, meaning that he's not going to be acceptable as well. Plus, he said he'd come see me before today, and he didn't.
He visited me.
Hold on a second, Mr. Jenkins. Hold on. Mr. Melachar is not from Colorado Springs. He's not from this county.
It's a friend of the court, I'm sorry.
Oh, he is?
It's Melachar first.
Oh.
He was a public defender here in Colorado Springs for some time. If you need the exact date, I can give it to you. But then he left, went to the Pueblo Public Defender's Office, and now he's in private practice.
Okay.
So I don't know where he lives, but I think he practices in those.
Okay, but he did practice here for some time.
For about a year, maybe a year and a half, it was mostly in Code.
Oh, okay.
And then he left.
Okay, so here's the deal, Mr. Jenkins. I had the Office of Alternate Defense Counsel, the person who's in charge of that, Darren Cantor, who's up in Denver. I had him look for someone who didn't have a conflict. And Mr. Melachar was identified as advisory counsel without a conflict. Would you like to talk to him?
No, I'll proceed without it because that wasn't recognized that he used to work for the public defender's office and it should have been. And therefore, it's the same as that we had an issue with the public defender's office to begin with, even though I didn't raise a conflict with Erin Sokol, there obviously was one for 100 days.
The issue with the conflict is that people know the victims in this case.
Absolutely, they've been in the same courtrooms, they probably had similar, I would have to look into it further. I'm a private investigator and I have other parties on the outside that can look into these things. So I quickly was able to find out that he was a public defender, and I know for a fact after my paralegal called
Okay,
around.
do you not want Mr. Melachar to represent you as advisory counsel? Okay, I'm
I'm
gonna go ahead and release, yes?
BRA, I didn't realize it moved to 1:30. I thought we always at 1:30, but it was set at 2:30. I know I talked to some victims yesterday and they were.
We're gonna have to bring you back.
Yeah.
Okay, so Mr. Jenkins, and I'm sorry about this, deputy, but this will free you up for some other things. I do need Mr. Jenkins to come back. I'm gonna be in the middle of a jury trial, so I'm not sure exactly when, but I will carve out a few minutes here to see Mr. Jenkins after 2:30. Is it okay if we contact you and you can just make sure Mr. Jenkins is waiting?
That would be great.
I really appreciate that.
We'll do our best to bring him in right when we can.
I can't tell you how much I appreciate the flexibility. Thank you for that.
Well, thank you for your flexibility.
Sure, okay, Mr. Jenkins, sorry about that. I'll see you at about I'll see you after 2:30, just when I can get a break in the jury trial, okay?
It sounds good, because there's some really important things to go over, so I appreciate you.
Okay, thank you.
Yes, ma'am.
Okay, let's go ahead and, I'm going to call Mr. Harris. Do I don't have Mr. But I don't have Mr. Harris. Okay. Let's call Mr. Anderson. Mr. Anderson, come on up, please. And this is 21 CR 4840, and Mr. Anderson is here for pretrial readiness. Mr. Anderson, I have Mr. Steckel, I have Ms. Freeberg, and let me just start by asking you, Mr. Anderson, you're gonna ask for a conflict hearing? Are you still asking for that?
Yes, I am, Your Honor.
Okay, why don't I start with that, then we'll have you back in a moment, Ms. Freeberg. Okay, and then who do I have in the back here, sir? Just an observer, okay. I'm gonna ask you to leave the courtroom because I have to clear the courtroom for this proceeding, and then I'll have you come back in. You're welcome back in anytime.
Thank you.
Just right now, I have to clear the room. Ms. Freeberg, could you police it just a little bit and try to get people over to Division 20 and not have them come in? Or somebody, I'm sorry to keep you in charge of that, but if somebody can help, thank you. Okay, go ahead and have a seat. And you can just stay seated if you like for this proceeding. This is a conflict hearing. And sir, you had asked for a hearing today, and you were concerned about having Mr. Steigerwalt represent you, correct?
Yes, Your Honor. As I had stated in my conflict motion that I had supplied to the court, along with the evidence in that I am a man, I'm a living, breathing, live flesh and blood human being. I am competent, and as a living, breathing human creator of rules, codes, regulations, and statutes, that I revoke my previous contract that I had with the court for appointing Mr. Steigerwald as my appointed counsel through the court. And so today on record, I am revoking that contract that I had with the court before by stating, yes, that I needed representation by a public defender. I do not need representation by a public defender as a living, breathing human being. I am competent, and this matter before the court, this thing I can have handled myself through the motions that I have also supplied to the court. I don't know if the court has had, you said you were doing a jury trial currently and had some other matters to attend to. I also filed 2 other motions yesterday with the court that also coincide and go along with revoking the limited authority of counsel that was appointed.
Okay, well, a couple of things. The first is you're represented by counsel, so those motions were denied because I don't accept pro se filings when you have counsel. So I denied those last night. Those have already been handled. The second is you don't have a contract with the court. You can call it what you want to, but I appointed the public defender to represent you per your original request. The third is I'm wondering if you're asking for a conflict hearing or if you're asking for to represent yourself. Do you want to have an alternate defense counsel appointed if I find a conflict?
No, I do not. I would
Okay.
like to represent myself pro se in this matter.
Okay, so it's not a conflict hearing. You're asking to have the public defender's office not represent you any further.
That is correct.
Okay, and you'd like to represent yourself.
That is correct.
Okay, so in that case, I don't need a conflict hearing. I just need to go through the advisement. But let me just say that before I do that, you have an opportunity if Mr. Steigerwald has a conflict, if there's a conflict there, you have an opportunity to have a different counsel appointed for free by the state of Colorado through the Office of the Alternate Defense Counsel. And it is generally an excellent idea to be represented by counsel. If you're not represented by counsel, you run an extremely large risk of damaging your defense in this matter. So I want you to just consider that before I stop this conflict hearing. Is it something that you want to consider?
I do not want to consider that.
Okay.
I would like to represent myself pro se or in propria persona, however the court determines that language as
you feel confident about that?
Yes, because I can speak plain English with the court, and I don't need any voice of ruin as far as the legalese and the terminology that the court can use. As I said, I'm an American, and I've served my country, and the rights that are guarded and safeguarded by the Constitution of the United States. I fought in foreign wars for my country, and
Mr.
in order
Anderson,
to.
I've got to keep it real short, okay?
Yes.
But I'm just going to ask you some really specific questions, and that's on Arguello. But first, if you could, that would be great. I'm going to make this, have everybody come back in because this won't be a closed proceeding. So just stop for a second, okay?
Can I ask one question too?
Well, hold on just a second until I have the district attorney in, okay? Okay, so now, just for the record, I have Ms. Freeberg back, I still have Mr. Steigerwald, and the courtroom is now open to the public. I've unmuted the WebEx. And so, what I need to do next, Mr. Anderson, is give you what we call the Arguello advisement. It's under a case called Arguello. And the purpose of this advisement is just to ask you a lot of questions to make sure that you understand your rights in representing yourself. I will tell you the gist of this advisement is to basically tell you it's a terrible idea to represent yourself unless you're an attorney, okay? All right?
Yes, Your Honor.
Okay. I'm going to ask you to just move that microphone over for you just to make sure the record picks up everything that you're telling me. These are pretty much yes and no questions with a couple other exceptions, okay?
Your Honor, if I can, before we start,
Sure.
with regard to the motions that you said that had been denied because I had been represented by counsel, will I need to resubmit those motions back into the court, or will the court relook at those motions now that I'm not being represented by counsel. And
I'm
then,
gonna ask you to resubmit them if you need to, but they don't really make sense to me, Mr. Anderson, and that's one of the reasons that I think I need to really talk to you about your advisement, because I don't think you understand Colorado law.
okay, before we start, can I request that the court take jurisdictional notice over the American Jurisprudence Book 16, American Constitutional Law section, before we start the advisement, please?
No. And so I'm gonna ask you some questions. How old are you?
I am of legal age.
Are you 18 or older?
Yes, I am of 18 or older of legal age.
What's your birthday?
That is not relevant to this case or the matter, Your Honor.
Were you born?
I was born a
What's your
natural
birthday?
living human being in America.
Mr. Steigerwald, is this what you've been experiencing?
Yes, ma'am.
Okay. How far have you gone in school?
That is not relevant to this matter.
Are you refusing to answer my questions?
I will exercise my Fifth Amendment right for that answer of that question, Your Honor.
How far you've gone in school?
Again, I will exercise my right to remain silent.
Do you read, write, and understand English?
That is not relevant to this matter.
Are you?
I am competent, Your Honor.
Should I make a record?
I understand what she's trying to do. but-
No, I don't, I'm married to that. She needs to make a record that you have enough educational understanding to do this, and you just say.
I just said I was competent.
But that doesn't create the record.
Okay. Sir, do you have any recording devices on? Okay. Are you sure? Okay. Do you have a phone? Can I see it real quick? Just want to make sure we're just not supposed to have anybody in the courtroom right now. Can you just turn it on for me? Okay. What's that? That's, let me see. What's going on right there? Okay. What's our recording device? Okay, I don't mean to accuse you, I just have to make sure nobody's recording. Okay, why don't you leave your phone out while we're talking, okay? Okay, thanks. Just keep it, yeah, that's fine, that's totally fine, thank you, okay. So sir, what I'll do is I'll ask you questions. If you don't want to answer the questions, just say I don't want to answer them, okay? And then maybe that's the way we'll get through this, but I just have to make sure I make this advisement on the record, okay? All right?
Yes, ma'am.
Do you read, write, and understand English?
I don't want to answer that question.
Okay. Are you under the influence of any prescribed medications, alcohol, or drugs, and are you clear thinking?
I do not want to answer that question.
Okay, it's really important to me that you're clear thinking today, or I may have to send you for competency evaluation.
Again, Your Honor, for the record, I am competent and I am of legal age.
And so when I say a competency evaluation, if you're telling me that you're not thinking clearly, what I mean is I'll take you into custody and I'll send you to the state hospital, and that sometimes takes a lot of time. So you need to tell me whether you're clear thinking or not. I'm worried about that.
I am clear thinking.
Okay.
I am competent.
Okay.
I am a man, a living, breathing, live flesh and blood human being.
That's good. Do you suffer from or have you been diagnosed with any mental disorder?
I'm not going to answer that question.
And what is your typical occupation?
I'm not going to answer that question.
All right. The court has appointed you an attorney, but do you wish to represent yourself?
That is correct.
Okay, why?
As I stated on the record, and I will state again, I am a man, a living, breathing, live, flesh and blood human being. I am.
You don't really have to tell me that again. I can see you're a living, breathing, live human being, so you don't need to say that ever again, okay? So tell me, why do you want to represent yourself?
As I do not do attorneys, I have found them to be injurious to my life, liberty, and my freedoms, also my pursuit of happiness.
Okay. And why have you waited until now to raise that issue?
These are things that I have currently learned along the way and researching my own through case laws from the Supreme Court of the United States, namely Marbury versus Madison. There are also several others that I could state as far as Cruden versus Neely.
Okay, but why, every case law, but just tell me why you've waited this long.
Again, this court has already denied the ability to take jurisdictional notice over the American Jurisprudence, Book 16, American Constitution section, and that is where I have learned a lot of these maxims of law, and also the mandate or the limited authority that has been granted to this court by the Constitution of the United States, under God's law and under natural law.
Okay, could you, please tell me what he's charged with and what also the penalty is real quick? And in the meantime, do you understand the basic factual allegations that have been lodged against you?
I do not understand, and I also do not believe that the court has jurisdiction over this case or over the matter. I have not been presented with the facts or the elements by the prosecution so that I cannot properly allege or defend them. Also, there is no injured party within this matter other than the state, and the state cannot be an injured party with this matter. I also have proof in which I had submitted to the court, which is in the Marsden motion. I don't remember what exhibit it's under. That, and again, I don't have anything in front of me to make reference to it, as I don't have access to the court files. I didn't know that you had also denied the 2 motions in which I submitted to the court yesterday. And so I don't get to see any of this stuff. None of this stuff is presented to me, and so I cannot make a proper defense against the alleged allegations.
Mr. Steinberg, did you get a complete information and you for the reading advisement? Okay, so the complete information, count 1 is second-degree burglary, that's a level 3 felony. Count 2 is first-degree criminal trespass, that's a level 5 felony. Count 3 is obstructing a peace officer, which is a level 2 misdemeanor. Count 4 is violation of a protection order, which is a level 2 misdemeanor. And what are the possible penalties?
Your Honor, for burglary, the F3, the possible penalties would be 4 to 12 years. I don't have his criminal history here to look at. Okay, he doesn't have any years.
There's no aggravator.
No aggravators, sorry. And for the F5, that would be the trespass to dwelling, that would be 1 to 3 years.
Okay, so those are the possible penalties and those are the charges. The basic factual allegations that are brought against you are by way of the PC affidavit, the probable cause affidavit. Have you shown that to Mr. Anderson?
Everything has been shared over email, right?
Okay. But including the probable cause affidavit?
It's part of the discovery, yes.
Okay, thank you. And so all of the discovery has been shared with Mr. Anderson via email? Okay, thank you.
I'm sorry, can I ask, was this prior to June 10th, which is the original scheduled date for this hearing, because June 12th?
Hang on a second, when was the date that you shared the discovery?
It was before June 10th.
Okay.
I'd have to go back, I can go into Dropbox, it'll take me a minute.
Okay, so that will tell you the basic allegations that are brought against you. If you look through the discovery, which has all been provided to you before December 10th, I'm not allowed to give you legal advice and I can't comment on the viability of any defense, but do you have a general idea of the defense that you'd like to lodge in this case?
Well, at the moment, no, I don't, because I was before today's hearing represented by counsel, and also back in June 10th under the original scheduled hearing date by a jury of my peers. That was continued to, I believe, October 10th now is what they're supposed to set for the new hearing date.
I'm sorry to interrupt you, Mr. Anderson, but do you have any idea of just the general nature of your defense?
I do not, because it has not been properly alleged to me. And again, when for the original hearing that was speedy ran on the 12th, which the court pushed it to the 10th of next month, which violated my 6th and 14th Amendment rights. I have not been able to properly allege a defense within the matter.
But if you are going to allege a defense, do you know what it's going to be? Is it just a general denial?
Well, at this time, I would like to request for an immediate dismissal of the case due to the fact that this court does not have, and I believe this court does not have jurisdiction. So I'm raising the issue of jurisdiction with the court here and today about this matter too. And if this court does have jurisdiction, I would like to see the jurisdiction duly placed into evidence. And I would also like to see who the injured party is, who brings this matter, who is this case, and...
Mr. Steigerwald, what about competency issues?
I'm sorry, I would like to object. Why are we asking the previous public defender for
I don't think you're
this?
making very much sense, so I just wanted to see if your attorney, who I haven't actually released yet, is, raising concerns about your competency. I'm just asking him, and I'll talk to you in 2 seconds, okay?
So Judge, without trying to upset Mr. Anderson, I've done a lot of research into trying to find out how to communicate effectively while representing someone who kind of expresses sovereign type beliefs. I only say that as like the broad category that I'm looking for. There's not a lot out there for attorneys because we don't usually end up representing individuals who hold the types of beliefs Mr. Anderson is expressing because they fire us. But
Why do they fire you?
the research that I've done, people generally come back competent because they have an understanding of what's going on. They just all have beliefs that I don't think have legal merit necessarily.
Okay, thank you.
I would like to also state for competency on the record that I'm pro se and have been pro se in a DR case for over 1.5 years now, and I am competent within that matter, and that my competency has never been raised in question for that matter as well. So I don't see why there would be a matter or a reason for competency within this court.
Okay, thank you, Mr. Anderson. I'm gonna actually just read you a bunch of stuff, and I'm gonna ask if you have any questions about it at the end, okay? In order to represent yourself, you should understand the difference between a general denial and an affirmative defense. An affirmative defense has to be raised in a timely manner, and you can be precluded from asserting that defense at trial if you don't raise it in a timely manner. I would apply the same legal principles to you that I would to any attorney if you decide to represent yourself. Criminal law is complicated, and an attorney trained in this field could be of great help in preparing and representing your defense. Generally, you have the absolute constitutional right to represent yourself, but by doing so, you take a great risk of not properly handling your case. It's a good idea to have training in the law generally, including the rules of criminal procedure and the rules of evidence, which is my understanding you may not. You also have to take upon your own, you would have to take responsibility for filing your own motions, but they have to be grounded in law, and so far, the motions that I've seen you try to file pro se have not been. And so that concerns me that you're not aware of what the law is. If you represent yourself, you would be responsible for raising any legal issues that you believe would be relevant to the case, and I'm not allowed to do that for you. The right to raise a legal issue can be deemed waived if it is not raised in a timely manner. You have to make contemporaneous objections, and in the event of a conviction, you'd only be allowed to appeal those issues which have been adequately preserved in the trial court. You'd have to be able to complete legal research, and the law libraries can be limited. The ones that are available to the attorneys are generally much more extensive. You have the right to confront and cross-examine witnesses who appear against you at the trial or evidentiary hearings, and you have to know how to do that. You have the right to call witnesses to testify on your behalf at the trial or in an evidentiary hearing, and you have to subpoena those witnesses or produce, send a subpoena ducis tecum, so you have to know how to do that. You have the right to testify or to remain silent at the trial, and there's a difference between testifying under oath as a witness from the witness stand and making statements from the podium here, which are not made under oath, and you need to understand that. You may only comment in opening statements on evidence that you in good faith anticipate would be admitted during the trial, and you'd only be able to comment in closing arguments on the evidence that was admitted during the trial and any reasonable inferences therefrom. So those are the advisements I wanted to give you. Do you still want to represent yourself?
I still want to represent myself, and I do not consent to the matter, and I am here under duress. If I am here at all, I'm here under a special appearance.
Okay.
And I see that there's a yellow fringe around the flag, which clearly indicates that admiralty matters are settled here in this court. And I would like to see the contract in which I knowingly and willingly, with full consent and knowledge, entered into a contract with the court and these
Mr.
individuals.
Anderson, do you understand that you do have that constitutional right to represent yourself, but by doing so, you take a very great risk of not properly handling your case?
Ma'am, I understand that
Okay,
the
and then let me
Constitution
let me just say one more thing. Do you understand that even if you are to do a good job in handling your case, you may be prejudiced by the jury seeing you act as your own advocate? For example, many people believe it is more persuasive to have someone else advocate for you. Do you understand that?
Well, before I say anything on that matter, ma'am, the Constitution and all laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary are notwithstanding. So again, I say for this matter, I do not consent, and I am here to address, and that this matter, this court does not have jurisdiction over, and I'm here to challenge that jurisdiction and have this matter dismissed.
Okay, and I'm gonna deny your motion to dismiss. I do find to have jurisdiction. And so,
May I see the jurisdiction placed into evidence, please?
with respect to your advisory council, would you like to have advisory council? Basically, advisory council's only role would be to explain legal terminology and procedure to you.
Again, you and I are speaking in plain English terms right now. I do not need a legal counsel in order to speak legalese with the court.
I am willing to give you an opportunity to seek a second opinion about this decision, because it's a critical decision. Do you want to talk to another attorney about this?
I do not want to talk to another attorney about this. I would like to have this matter resolved and dismissed here today, because this matter, the court does not have jurisdiction over this matter, and the state cannot be an injured party within this matter, as there's not been
Sir,
a
with all due
witness
respect, I
presented.
won't be dismissing the matter. I do have jurisdiction. Is anyone pressuring you to represent yourself or making you do this against your will?
No, there is nobody pressuring me into representing myself. The only thing that is pushing me to do this is the fact that the court has overstepped its boundaries by also violating my 6th and 14th Amendment rights under due
And you've said that
process.
before. You've also raised jurisdiction. I'm rejecting those arguments, but thank you. Ms. Freeman, anything else before I make my findings on the Arguello advisement?
No, Your Honor.
Okay, I'm gonna go ahead and make findings, and then I'll ask you a couple more questions, okay, Mr. Anderson? The court has observed the defendant's demeanor and listened to the defendant's answers to the court's questions. I've also asked Mr. Steigerwald various questions, and am finding Mr. Anderson competent, at least today, to be able to answer questions. While he's not making rational statements, I do find him to be appropriately oriented, and I don't see any evidence that he's under the influence of any prescribed medication, alcohol, or drugs. He's expressing sentiments that appear to be maybe sovereign-related sentiments, but I'm not understanding them. The court has not witnessed behavior which would cause the court to feel the need to raise the issue of defendant's competency, at least today. The defendant has been represented by court-appointed counsel, and counsel has confirmed that the defendant should not be evaluated for competency. I do find that the defendant has a understanding of the proceedings against him, at least that I've read to him today, and then we've discussed through the district attorney the penalties that are being brought against the defendant. And I'm persuaded that he is making a knowing and informed decision to represent himself. He's being very clear that he wants to represent himself today. I do find that I've advised Mr. Anderson of the dangers, disadvantages, and responsibilities of self-representation, and he has expressed very clearly that he wishes to exercise his right to self-representation in spite of those dangers, disadvantages, and responsibility. And therefore, I find that he's making a voluntary, knowing, and intelligent waiver of his right to counsel today. And so, sir, you will be representing yourself from this moment forward. Mr. Steigerwald, you're relieved of your appointment in this matter. And Mr. Anderson, what we're here for is a pretrial readiness. Your trial is on October 10th, and are you announcing ready to go to trial?
I am not. I do not understand the merits of this until they have been properly alleged by the prosecution under the advisement that this court has just given.
Are you announcing ready today?
Yes.
Okay. So, Mr. Anderson, you have two questions, two options today. I have found that your request to dismiss the case and all of the other requests you're making are denied. And we are going forward with trial on October 10th unless you seek a continuance. If you want a continuance, you can have a continuance. Otherwise, we're going forward on October 10th. Those are your two options.
And how long do I have to request a continuance? Is that only here today, or can I put in a motion to the court?
Today, you need to request a continuance if you'd like one. If you do, you will be waiving your right to a speedy trial.
That's already been violated by the court, so I don't understand that with the merits to the Constitution, because as I stated,
If you want
June
to
12th.
request a continuance today, you would have to waive your right to a speedy trial. It would reset and you would have your speedy run in 6 months. Otherwise, we will go forward on the 10th of October and I will have a jury here and you will have a jury trial.
I'm under the understanding that the courts have already exercised and waived my right to speedy, because
And you're
again,
wrong,
speedy
and
was
so
on
I
the
have a
12th of
question for you,
June.
and it's a very specific question. Either you waive your right to a speedy trial and request a continuance today,
I do not waive my right to a speedy trial.
then we will have a trial on October 10th.
I
It will be at
reclaim-
8:30, and you will be here at 8:30 a.m. on October 10th. There will be a jury, we will have a panel, and I will explain you some of the procedures to you at that time.
I am requesting right now in a verbal motion that it be a jury of my peers, not just a jury trial. It must be a jury of my peers pursuant to my Fourth Amendment right under the Constitution of the United States. I'm sorry, my Sixth Amendment right.
Yes, you will have a jury of your peers, that's how we select juries. So, I will see you here for your trial on October 10th at 8:30, you'll be representing yourself. You have any more questions about the trial for me?
I do not.
Okay, then I will see you then. Anything more, Ms. Creeper?
I just wanna make sure that, Mr. Anderson has a copy of the discovery if he wants it, and if he needs that, he needs to go to our office and request it. They'll provide it to him, but it's not instant, it might take a few days, so if he wants that, he should go right now.
Do you need the discovery again, what Mr. Arguello gave you before June 10th?
Yes, it was before June 10th, as that was the previous speedy that the courts, again, have already violated. So I
My
do not
question
have
is
the
not-
current.
Mr. Anderson, that's not my question. My question is, Mr. Steigerwald sent you the discovery. If you need it again, you're gonna need to go to the district attorney's office today.
Again, for the record, there's been, almost 6 months since speedy was last violated. So I don't know what they have had in between then and now, or up to the trial date. And so yes, I'm going to request it now here on the record that they present another discovery to me.
So he has to go to our office.
You go to the district attorney's office and they'll give you the discovery. You can do that today, and I advise that you do that today. I'm gonna order you to do that today, okay? Any other questions about the trial? No? Okay, I'll see you on October 10th at 8:30. Thank you. And now I'm going to, ask about Mr. Harris.
Yeah, she'll be here.
Going down. First floor.
It doesn't